Hello, welcome to another edition of Matters of Law. Matters of Law, the law reigns supreme. Catch us on YouTube on extvgh and explore tvgh on Facebook. Last week, we talked about execution processes after judgment. Yes, there are a lot of questions which have come up on that. So we'll do a part 2 and an extended version where we'll answer some of the questions which have come up. Let's go for a spot of commercial. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. So, following our discussions last week on the execution process after court has given judgment, a few of you sent us questions to deliberate on certain matters. So we'll try to answer those questions and also do a little bit of education on other things that may happen when you have been given judgment. The first point I need to make is that when you have been granted judgment, you have every single opportunity when you are filing for the entry of judgment to state exactly what has been stated in the judgment. In fact, there's a Supreme Court directive or a party's direction which requires that the registrars coordinate or collaborate with the litigants to ensure that exactly what has been stated in the judgment is exactly what they are entering or doing or putting in as their entry of judgment. Now, what happens if the court orders you to pay an amount of money and you are unable to pay that amount of money? There was a question like, can the person be imprisoned because the person is unable to pay the money? In other words, the person is asking for contempt proceedings against such a person. Unfortunately, when a court makes an order for payment of money, as in terms of a judgment debt, you cannot be imprisoned for your inability to pay that amount of money. The other processes that are available, or the process that are available to deal with such a person or to deal with such a matter, is either you are going for garnishee proceedings or you are going for a writ of fife. So what happens if you decide to go for a writ of fife? That is, you want to attach somebody's property to be able to satisfy a judgment debt. Now, if you go and attach any property, that property does not belong to the judgment debtor, that means the one who has lost in the said judgment, then whoever owns that particular property can do what we call interpleader proceedings. Now, what is the interpleader proceedings? You need to sue a lawyer who will file an application before the court to make the court know that property which has been attached in satisfaction of the said judgment, that property does not belong to the judgment debtor. You need to act timeously so that the property is not attached for the purposes of satisfying the judgment. It may be that property is co-owned by the judgment debtor and the judgment debtor and some other person. Where there's co-ownership, obviously that cannot be, the whole property cannot be used in satisfaction of the said judgment debt. So if you are a co-owner of that property, you need to see a lawyer where they'll file interpleader proceedings in court. Now, what happens if you have done all your filing, everything, and you notice that the amount of money that you realize from the said execution will not be enough? Your duty is to take further steps to ensure that you attach other properties of the said judgment debtor, or you take other steps or other execution processes that are available to you. That is why I said, before you take any matter to court, you should be sure in your mind the properties that belong to the said judgment debtor, whoever you are taking to court, so that you are very much assured that you can get some property to levy judgment on, what we call levying of judgment. It is important for us to understand that you need to know the various actors in the court when you are doing all these processes. The first thing you also need to know is that the registrar of the court is one key person who all these processes will pass through his hands. If you need to file any affidavit, if you need to attach any exhibit, any document, anything whatsoever, it is the registrar who will certify that in the affidavit that yes, indeed, these documents have been attached to the application that you want to bring before the court. It is also important for you to know that every single exhibit that you file in your applications, you must make sure that they are duly filed and every single exhibit has been duly noted as an exhibit. So whatever document you are presenting, when you get to the filing clerk, ensure that all those documents are properly stamped and are properly taken into consideration when it comes to the filing of your applications. And make sure they have fully paid the right amount for every single process that you are filing. That is one. Two, if any process has to be served on the judgment data, then you have to ensure that the processes are duly served by the bailiffs. Now, how do you know that the processes have been served? Every single court process that is served, there's what we call proof of service. So it is the duty of the bailiffs to prove service. That is a document that they write to state that indeed they have served whoever they are supposed to serve. It is also important for you to know or for you to find out whether the lawyer for the judgment data would be in court. This is to save you cost and to prevent cases where the lawyer may not be in court and for which reason you may have to take an adjournment. It is your duty to remind your lawyer to be able to contact the lawyer on the other side where he has his contact, so that you do not come to court and have to go for an adjournment. It is also very important that sometimes you check with the registrar whether the case has been fixed for hearing at the court. You may go to a court and you realize that somebody may forget to get the docket to the attention of the judge. So although it may have been fixed for that particular day, the docket may not have been placed before the judge. In all of these processes, remember that even if judgment has been given against you, you can file an appeal against the decision of the court. Now, in filing an appeal, you need to have gotten a copy of the judgment and the proceedings. If you are not satisfied with the decision of the court and you file an appeal, that doesn't end it. You will need to file a stay of execution of the said judgment. Now, when we say stay of execution, what does it mean? It simply means that whatever we have decided to do, whatever was given in the judgment, you don't want them to take any single process to ensure that they get the benefit of the judgment until the appeal has been dealt with. So when a stay of execution is filed at the trial court or the court which initially gave the decision, the judgment creditor is not supposed to take any action until that stay of execution is determined. Now it's a process that is filed by the lawyer for the judgment debtor. You may be aggrieved with the decision, you may be aggrieved with part of the decision. So when a stay of execution is filed, you can't go into any process of execution unless the court has determined that process or that application that has been filed. If the court determines the application and the court is of the opinion that the stay of execution lacks merit, the court will dismiss the application. In that case, what you are required to do is to file a repeat application at the appellate court. Now, your repeat application will simply be to say that this particular matter having come before the court should take into consideration all the necessary things that you have said and the fact that there's a likelihood of your appeal to succeed. In all these processes of execution, it is important to follow the rules of procedure. You do not get up to do just anything at will, and you always have to ensure that all the necessary documentation that you need to attach to your applications are attached to your applications. If there are any pictures you need to attach, you attach them. If there are any videos you need to attach, you attach them. If there are any documents you need to attach, you attach those documents. And you need to know and you need to understand that the court works with documents. So any document that you have to attach must be clear and must be very legible, so that when it appears before the judge, you are able to get a very fair hearing and a just hearing. Now, what happens if your appeal is not granted? Of course, if your appeal is not granted, depending on the level you have gotten to, if the decision was given by a high court, and it goes to the Court of Appeal, you still have opportunity to appeal against the decision of the Court of Appeal to the Supreme Court. It all depends on the decision that was given by the appellate court. In the case, it may be the Court of Appeal. If your decision is coming from the district court in a civil matter, it will definitely come to the High Court. If you are dissatisfied with the decision of the High Court on appeal, you appeal to the Court of Appeal. Same way, if you are dissatisfied with the decision of the Court of Appeal, you appeal to the Supreme Court. It is important for us to understand that all these processes are governed by rules. If it's the district court, we have CI 59. If it is the High Court, we have CI 47. And if it's the Court of Appeal and the Supreme Court, they have their various rules which govern them. If you do not understand the rules, if you sidestep the rules, then you are going to be found wanting. Execution processes are very technical processes, and one is required to stick to the rules that have been set, so that at the end of the day, you are at ease, or you get the benefit of whatever you have decided to do. Let me do a quick recap. We talked about whether when a court gives an order for money to be paid, or there's a judgment that if somebody does not pay, whether contempt proceedings can be brought against the person. Definitely you can't bring contempt proceedings against the person. We also talk about filing of stay of execution, that if a judgment has been given and you are dissatisfied with it, before the judgment creditor goes into executing it or takes any process to ensure it gets the benefit of the judgment, you can file your notice of appeal and file your stay of execution. Until the stay of execution is heard, nothing will be done in respect of any form of execution. You need to be timeous in that application. I also mentioned that if there's an interpleader process, if somebody attaches your property in satisfaction of a judgment debt, if you know that that property is not for the judgment debtor or the one who has lost the judgment, then you need to see your lawyer so that you file interpleader proceedings to be able to make a claim to the said property. And I also mentioned that every single process that you file with the registrar, you need to make sure that it's properly stamped, the right amounts have been paid, and you have followed the rules of the court so that you are not found wanting. And lastly, not to forget, whatever process you are filing as entry of judgment, it must comply with the judgment that was truly given. Thank you for making time with us on Matters of Law. Matters of Law, the law reigns supreme. Share this with somebody, as it may be very important for the person. Catch you same time next week. Bye-bye.
To support this program, contact XTV on 024-606-1095 or 050-836-4159, or send us an email to info@stvgh.com.